So hi everyone. In the last class, we are discussing about the concept of the agency. And the concept of the agency, we have discussed that how an agency is being created and what is the duty of a principal as well as the agent in the terms and conditions of a contract. Okay. So whenever we have discussed about an agent, then we have understood that who can be a agent, who is called as an agent. Specifically, the person who takes care of the specific things of the principal. That person is called as an agent of the principal. For example, I have been appointed on behalf of the principal to take care of the activities of the principal, and thereby I will be called as the agent of the principal. Got it? So, whenever we are talking about the agency, that means the representation of the principal to through the agent for any specific kind of the activities. That is called the concept of the agency. That means, for example, I was supposed to attend a meeting at Manali tomorrow, but due to certain issues, I am unable to travel Manali or I am unable to go to that specific place. Okay. So when I am myself unable to perform that duty or to unable to perform my work, then I am appointing someone on my behalf to do that specific act. And that person is called as my agent. So, in this concept of the agency, we have understood that when there is the presence of the principal, there is the presence of the agent is also there. Okay. So, when the principal is unable to perform his act by himself, then he appoints someone as his agent to perform that specific activity. So this is what we have understood about the concept of the agency and the principal. Okay. And under section 206, we have understood about the notice of the revocation or renunciation, in which we have understood when there is the revocation or renunciation that must be expressed or implied through the conduct of the principal or the agent respectively. Okay. Okay, so in the last class, we have discussed about the concept of the agency and we have understood about the concept of the agent's duty in naming of the such person. And I have also made you understand the specific thing under section 193, that when there is the responsibility of the sub agent to be appointed by the agent, then what happens in that specific manner? We have understood that when there is a sub agent has been appointed. For example, I am the principal over here and I have appointed you as my agent. So then who are you? You are my agent over here. But when being an agent, you are appointing someone else to do your activity. That means that the person or the third person is being appointed to perform your duty or your responsibility. Then that person is called as the sub-agent who is working under the agent. The person is called as the sub-agent. So hereby the principal is the primary authority. Under the principal, who is the secondary authority? The agent to whom the principal has been appointed for any kind of the specific activity. And when the agent is appointing someone as the sub agent, then the sub agent is working under the agent to perform his duty and his responsibilities according to the instructions of the agent. This is what we have already understood in the last class. And continuing further, when we have discussed about the concept of the agency, in that course of action, I have already made you understand that what happens. when a principal gives the responsibility to the agent to appoint another agent. For example, I am the principal over in a specific circumstances. I am the principal. So what I am doing, I see that you are already working as my agent, but you are unable to perform all the kinds of the works because you are the single person. This is being very hectic for you to handle all this kind of the stuffs. So what I am doing, I am hiring a specific person to do your work, or I want to hire someone as my second agent to help you in your work. So in that circumstances, if I am giving you responsibility that see, now you are doing the very hard work, or your task culture is really getting difficult for you to handle, so I suggest that you should appoint someone as an another agent which will be helpful to you. So the secondary person who is being appointed here, what he will be called? He will be called as an agent only, because as we have already understood, even if that person is being appointed by the agent, even if the agent has appointed that person, but it is the specific instruction of the principal. Hereby, the principal has instructed to the third person, or the principal has instructed the agent to appoint another agent. So here, the second agent, or the new person who is being appointed by the agent of the principal with the instruction of the principal, then in that circumstances, the agent will be responsible for his activities directly to the principal. But if there is a appointment of the sub-agent by the agent, then the agent is answerable to the principal for the activities of the sub-agent. But when the situation comes that the secondary agent has been appointed with the instruction of the principal, and the primary agent has already appointed the secondary agent, so if the secondary agent or the newly appointed person does any kind of the mistake, then in that circumstances, who will be responsible for the activities of the agent? The principal will be responsible for all the activities of the agent. Okay. So this is what we have understood under section 193. And we have also understood the relation between the principal and person duly appointed by agent in act of the business of the agency, under which we have understood that the sub-agent is responsible or answerable to the agent for all of his activities. But here the agent who is appointed by an another agent to do continue the different activities, then that person is himself responsible to the principal directly for his activities. Even if the agent has appointed his, but here that person has not been appointed as the sub agent. He has appointed as the direct agent, and agent is directly responsible to whom? To the principal. Got it? So, section 195 speaks about the agent's duty in naming such person. So, whenever we are talking about the duty of the agent in naming of the such person, then how does it work? In selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of the ordinary prudence would exercise in his own case. And if he does it, he is not responsible to the principal for the acts or negligence of the agent so selected. That means, so when the agent is selecting such agent for the principal, the agent must follow the proper criteria of the appointment. This is the first thing. And the second thing, he is not responsible to the principal for the acts or negligence of the agent. That means, for example, I have appointed you to appoint someone as my agent. So, for example, I have appointed you as to handle my business stops, and you are working as my agent, okay? And in the same time, I'm opening a new shop at a specific place. So hereby, I feel I should appoint someone who is very responsible to take the responsibility of the business and all. That is why, as I trust you, I came to you. I told you that, see, you are already working in my shop for the years, okay? And you are already working my agent, and I trust you. So I'll give you the responsibility to appoint some person or appoint a specific person to carry the business, and that person will be the another agent of mine who will handle the business, the another business affairs, okay? So here, as I have given you the responsibility of deciding the circumstances, as I have already given you, okay, the the responsibility to select someone as my agent, to take care of the responsibility to appoint someone as my agent, then what will happen? In that specific circumstances, when I am giving you the responsibility to do something, it is also your responsibility to be careful for the circumstances. That means it is also your responsibility, it is also your duty to understand the nature of the agency. And most importantly, whenever I am appointing you someone, to appoint someone as the agent, you must figure out or find out someone who is actually eligible to do this task. Got it? So this is what we have understood under section 195. And yes, one more thing, the person who is not the who is and the next important point is the person who is working along with the agent or who is been appointed by the agent is not responsible for any kind of the activities of the third person. That is why whatever the activities is being done, for that the principal will be directly held liable. The agent is not going to be held liable for any kind of the activities. Got it? Then comes the concept of the ratification. So whenever we are talking about the ratification, so what do we understand? Ratifications means the agreement is subject to ratify by the parliament. That means when something is permitted or something has been given the consent thereon, that is called the ratification. And the opposite term of the ratification, what is this? This is called revocation or denial. Got it? Sorry for the interference. I have got a call actually. Okay. So whenever I'm talking about the ratification means giving approval for a specific thing or specific action. That means, for example, you are asking me that, ma'am, can I bring the groceries to the home? Then I am giving you the ratification that yes, please go and do this. So hereby, I am providing my consent or my approval for a specific activity. That is called the concept of the ratification. Got it? So, when we are talking about the concept of the ratification, it means right a person as to acts done for him without his authority. Where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts. If he ratify them, the same effects will follow as if they had been performed by his authority. That means when we are talking about the effect of the ratification, how does it work? When we are talking about the effect of the ratification, it means if someone acts on behalf of another without permission, for example, I am working on behalf of A without the permission of the principal or without the permission of the specific person, then it is called the ratification or approval of the act. In which way? Making it valid if it authorized initially. That the, for example, I have appointed someone to take care of my shop, okay? So that person to whom I have appointed, he is my agent, okay? But due to the lack of time, my agent is unable to give sufficient time to my shop. So what he is doing, instead of regularly taking care of the shop, instead of regularly going to the shop, what he is doing, he is he has appointed someone else to take care of the shop. That means he said me that he was unable to go to shop on a daily basis due to his some certain kind of the issues, and that is why he has appointed someone else in the course of the appointment to carry forward his all the tasks and his all the works, okay? So in this kind of the situation, this is called the concept of the ratification. Got it? And most importantly, ratification can be approved or accepted or can be disowned. That means it can be declared as invalid. Got it? Section 197 explains ratification may be expressed or implied. What does it mean? Ratification can be expressed, that means it is clearly stated approval, and implied means it is shown through the action, that is using benefits of the act. Got it? Okay. So under section 196, this speaks about two basic concepts. First is the approval of the ratification, and second is the disowning or the negotiating the notification. Okay. So it is up to the principal or the agent that what he or she exactly wants. If he wants or she wants, he or she can proceed with the same. He or she can proceed with that particular activity, and that will not come under the act of the ratification. But if the partner is not willing, if the person or the principal is not willing to do their task, so yes, the the ratification can be disowned or denied or can be declared as invalid. Okay. So moreover, under section 196, it speaks about the right of the person as to act done without his authority. That means the ratify or approval of the act, making it valid when it is declared as an authorized act. And if the principal wants, he can still declare the act as invalid. Got it? So, one more thing. When we're talking about the ratification or the approval of the thing, okay, then we need to ask one more thing, that when the thing is being approved or when the thing is being ratified, that yes, this is going to happen, that is going to happen, then who is the specific person who needs to accept the fact? That person is called the principal. Here the principal must be responsible, must be liable, and must be concerned about this act of the ratification, or or this act of the saying yes or no to a specific thing. Okay. So when a person is the, or is, for example, there is a person who is the owner of a shop. That is what we have just discussing few times back. Okay. And that person has appointed B to take care of the shop. Okay. And in the course of action, in the circumstances, what happened? When you have appointed B to take care of the shop, actually due to certain work schedule or certain any kind of the activity, B is unable to take care of the thing. Okay. Or B is unable to take care of the whole shop by himself. So what B is doing? B is appointing someone else as the sub agent of him. That means he is appointing some other person to be the sub agent of himself or herself, so that he can provide them uh, so that he can provide them the proper service. Okay. That is why when you have appointed B as your agent, B decided to appoint C as the sub-agent. So what happens in this matter? When C is being applied as the sub-agent, okay, and B is the agent, then it is upon the principal, because on the terms and conditions of the contract, on the nature of the contract, it was not primarily decided that this person can keep any kind of the sub-agent. Okay. But when it comes about the appointment of his sub-agent, when it comes about the appointment of a specific person who is acting as the sub-agent, if the principal is giving his or her ratification for the specific thing, that means the principal is telling that yes, I am happy on this and I accept this, then the ratification becomes complete. And hereby, the ratification, if it is denied, then the ratification becomes invalid. Got it? Then comes section 197. It speaks about the ratification may be expressed or implied in nature. What does it mean? It means it is the ratification which can be expressly, means clearly stated approvally. And when we are talking about the implied means it is shown through the actions of the person. Okay. As like we have understood in the previous sections also, in each and everything we have understood about the two modes. The first is the expressed and the second is the implied. The expressed means something which is written in the form, which has the oral evidence, which has the written format, and that is called the written evidence, and that is called the uh, expressed. Whenever we are talking about the implied consent, what do you understand by the implied consent? Implied consent is a kind of the consent which has been provided through the course of action. That is implied. Here the consent or the appointment or the authority need not to be shown or need not to be spoken. His behavior or his activities himself implied, the ratification may be implied in nature. The first point, the ratification may be expressly or implied in nature, section 197. Okay. So section 197, when it speaks about the ratification may be expressed or implied, then whenever we are talking about the express, That means when the ratification or the approval or the rejection is being done, it must be clearly stated approval. It must be approved in a very, very clear manner. Then implied when it is defined through the court of the actions or the course of the actions. For example, using the benefits of a specific act that comes under the implied activity. For example, uh, take an example of this, just like in the course of business, okay, I am appointing someone to take care of my business, or that person is being appointed by my agent, okay. So when that person has been appointed my agent without my permission or without my consent, that person has kept someone else as the sub agent. So the third person over here became the sub agent of the agent. Got it? Okay. So when we're talking about the implied consent, let's understand this. Okay. When, uh, for example, the third person who has been appointed, the third person started taking care of the things. Okay. And most importantly, whenever we're talking about the implied consent, it means using benefits of the act. That means whenever we are talking about the implied consent, the consent must be visible through the activities. It must not be spoken by the words. That yes, I am from this, I am doing this, I'm doing that. Okay. That must be expressed through the implied activities or implied actions. So, whenever we are talking about the implied ratification, then what is happening? That for example, I have appointed a person as my agent, and instead of going to the business on a regular basis, what B did, with a certain few price, B has appointed someone else as the sub agent of the property. Okay. So when the sub agent or the agent under the specific thing, or the agent under the agent, the sub agent, okay. For example, when the sub agent is being asked to perform his duty in a proper manner, and that person is also performing his duty, the sub agent is also performing his duty in a very, very clear manner, okay. And the principal who has not permitted before about or regarding the appointment of the sub agent, then in that specific circumstances, the implied actions which is made by using the benefit of the activity, in that case the ratification is called as the implied ratification. Got it? Then comes section 198. It speaks about the knowledge required for a valid ratification. What does it mean? Whenever we are talking about a valid ratification, that means a ratification which is valid in nature. Okay. That means section 198 speaks ratification is valid if the person lacks full knowledge of the fact, that when the person is having the half knowledge about the fact, then the ratification is not completed in nature. For example, you have appointed without my consent someone as your agent, so you are the agent over here. Then what became, you became the principal and you have appointed someone with your with your consent, but without my consent. You have not taken any permission from the uh, original owner regarding the responsibility, or you have not taken the permission from me to take care of the things. But what did you do? You came, you told that yes, I am unable to handle the works, and that is why you have appointed someone as your sub agent. Okay. For example, I got to know about this after some days. Okay. So when I have got to know that yes, the person has appointed someone else as the third person, then in that specific circumstances, whenever we are talking about the required knowledge of the valid ratification, then we need to understand the ratification is valid if the person lacks full knowledge of the fact. That if the person does not have the full knowledge about the fact, then those kind of the ratification is called as the invalid ratification. Because before ratifying something, before approving something, or before ignoring something, the major thing that is needed about the full concept or the full knowledge about the required about the required valid ratification. That what is the terms and conditions of the contract, what is the sequence, what are the circumstances, that is very very important to know. Okay. So whenever talking about the knowledge required for the valid ratification, that means when there is a ratification concept comes to the force, then the ratification is invalid if the person lacks full knowledge of the fact. That means to make a ratification valid, the most important thing that is needed is to full knowledge of the fact, that what the fact is all about, what is the nature of the fact, how the fact actually works, that need to be taken care of. This is called under section 198 knowledge required for the valid ratification. Okay. And then comes section 199. What does it mean? It speaks about effect of ratifying the part of the effect of ratifying the part of a transaction. Ratifying one unauthorized act means ratifying the entire transaction in part of. So, under section 199, when we have discussed about the effect of ratifying the part of a transaction, then how does it work? Ratifying one unauthorized act means ratifying the entire transaction in its cost of. And whenever we are talking about section 200, it speaks about the ratification cannot harm the third persons. And it exactly speaks that an unauthorized act that would harm the third party cannot be a valid ratification. That when there is an unauthorized act and that has harmed the third party, that cannot be a valid ratification ever. Got it? Got it? Then when we are talking about section 199, it speaks about the effect of ratifying the part of a transaction. What does it mean? Ratifying one unauthorized act means ratifying the entire transaction is proof of. Okay. So under section 199, when we have discussed that it is clearly written that effect of ratifying unauthorized act forming part of a transaction, a person ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of such act formed a part. Okay. That means if a person ratifying any unauthorized act done in his behalf ratifies the whole the transaction in which such act is formed. That means, for example, there is a unauthorized act that has been done during the course of the transaction. And when the person is denying the specific part of the act or refusing the specific part of the act which is unauthorized in nature, then along with the unauthorized part of the act, the person cannot by ratification be made to have such effect. That means here when we are talking about the ratification of the unauthorized act that cannot injure the third person, and we have understood that when there is a series of the activities which is forming a course of the transaction, and in that course of the transaction one specific part is considered as an unauthorized act or illegal activity, then if the person is denying that specific part of the act, then the whole of the act declared as invalid. Got it? And when we are talking about the ratification of unauthorized act cannot injure the third person, that means an unauthorized act that would harm a third party cannot be validated by ratification. Okay, so when there is any kind of the activity which is harming the third party, should it be considered as the valid act to give permission? The answer is no. When there is any kind of the activity which is forming harm to the third party, danger to the third party or damage to the third party, in those activities, that specific activity is called as the unauthorized ratification in nature. Got it? And section 201 speaks about the termination of the agency. Got it? And how does it work? Section 200 speaks about the termination of the agency. How an agency is being terminated. Then how we can speak about the termination of an agency. The principal revokes the agent's authority. The first point. The second point, the agent renounces the agency. The third point, the purpose of the agency is completed. The fourth point, either party dies or becomes mentally unsound. And the last point, the principal is declared insolvent. So, what can be the reason to terminate an agency? एजेंसी को टर्मिनेट करने का क्या रीजन हो सकता है? वी आर गोइंग टू अंडरस्टैंड अंडर सेक्शन 201. The first point is when the principal revokes the agent's authority. That when I am the principal, but I am seeing there is a certain kind of the disturbances within the activities of my staff. Okay. So in that circumstances, the principal revokes the agent's authority. The principal is denying the agent's authority. And the second point speaks the agent renounces the agency. That means at the first point, the principal is removing or denying the agent to continue his agency. And at the second circumstances, the agent by himself renouncing his agency or denying his agency. He is telling that no, I don't want to continue with the agency. Who is telling? The party, the another party. That means the agent is speaking that I do not want to continue the agency or I am terminating the agency. The first point speaks when the principal revokes the agent's authority. When there is the presence of the principal and the principal is saying the agent that no, I am terminating your authority from now on and you are unable to continue the authority from now on. The third point, the purpose of the agency is completed. The third point, what is most important? The purpose of the agency is being completed. The purpose for which the agency has been created, it has been completed. For example, I was supposed to attend a meeting at Delhi, but I am unable to go. And for the specific time period of the 10 days duration of the time in which you are supposed to attend the meeting on behalf of me, I am appointing you as my agent. So when the task is completed, the meeting is done, what is the need to continue the agency? The agency can be terminated in that case. Next point, either party dies or becomes mentally unsound. Any of the party is dead or becomes mentally unsound. It might be the principal or it might be the agent. Any of the party has either died or became mentally unsound. किसी का मौत हो गया है या फिर कोई mentally unsound बन गया है, mentally unstable बन गया है. And the last point, the principal is declared insolvent. Where the principal is declared as the insolvent, the principal has no such money to continue the agency. So in these circumstances, the agency can be terminated under section 201 of the Indian Contract Act. Okay. So what are the points? The first point, the principal revokes the agent's authority. That means if the principal is there, the principal revokes or denies the agent's authority. The principal is saying the agent that no, I do not want to continue further as my agent. This is the first situation. The second situation, the agent renounces the agency, where the agent is himself saying that no, I do not want to continue the agency or I want to terminate the agency. The third party, the purpose of the agency is completed. जिस purpose से agency create किया गया था वो काम खत्म हो चुका है. चौथा, either party dies or becomes mentally unsound. इसी में से कोई पार्टी, it might be the principal or it might be the agent, any of the party has become mentally unsound. उसी का दिमागी हालत बिगड़ चुका है and that party died. किसी एक पार्टी का मौत हो गया है, दूसरा पार्टी का मेंटल हालत जो है, दिमागी हालत जो है वो बिगड़ चुका है. एंड द लास्ट पॉइंट, द प्रिंसिपल हैज डिक्लेयर्ड एज एन इंसॉल्वेंट. वहां पे क्या बोल रहा है? The principal is unable to continue with the terms and conditions of the contract, or the principal is unable to continue the agency, because when the principal becomes insolvent now, the principal is unable to continue his business, his course of action. अगर वो खुद ही अपना बिजनेस कंटिन्यू नहीं करने को रेडी ही नहीं है, देन वहां पे एजेंट का क्या काम रहेगा? क्योंकि इवन इफ द एजेंट इज वर्किंग फॉर द प्रिंसिपल, who is responsible to provide fund to the business? Obviously the principal. But यहाँ पे अगर प्रिंसिपल फंड प्रोवाइड नहीं कर पा रहा है ड्यू टू हिज बैंक्रप्सी or due to his situation, then in this kind of the situation what will happen? In this situation the agency will be terminated. This is what we have discussed under section 201, how the agency can be terminated. First, when principal revokes. Second, when the agent revokes. Third, when there is the purpose of the first, the principal revokes. Second, the agent revokes. Third, when the motto of the agency is being completed. Fourth, when there is a situation or circumstances that the party dies or becomes mentally unsound. And fifth, the principal declares as insolvent. So got it? The circumstances. First, the principal denies. Second, the agent denies. Third, when there is the purpose of the agency is completed. Fourth, the either of the party dies or becomes mentally unsound. And fifth, when the principal is declared as the insolvent. So these are the terms when the agency can be declared or terminated. So section 202 speaks about the agency with agent's interest in the subject matter that we are going to discuss in the next class. This is all for the today's class. We can drop the class here, guys. Thank you so much. Bye bye.